Hello, Dr. Bechtel here again. This lecture concerns Chapter 4 again of regarding finding the legal rule from the book A Practical Guide to Legal Research Analysis for Paralegal and Legal Studies Students by Margaret Phillips, published by West Academic in 2020. The full site to the book is on the last slide. I bifurcated from Chapter 4 the case law topics and the legislation topics as far as finding a legal rule. I think that it's a little easier to keep these two things separated so that students have a clear understanding of the differences. There are so many similarities in terms of this lecture and the one on legislation. There are some similarities, so you'll see some repetition. I'll also be referring to some other parts of the book that might help you as well in not necessarily expanding, but bringing together and synthesizing what we've learned so far. For example, Chapter 3. We'll get to that here in just a minute. So, start my laser pointer, move the slide. Okay. Same legal skills to be developed by working with this chapter and the chapter content, as well as the work that you'll do in class assignments. But it's the same ideas are coming to this one as in the other. As I pointed out already, there is overlap, obviously. All right, finding the applicable legal rule, and then when we take an in-depth look at search strategies, we're still dealing with case law, also including a recursive process with multiple steps or layers that we work through. Additional information will also inform us as to possible revisions to our search strategy and our searches as well. Chapter 3, the foundations of this chapter come from Chapter 2 and Chapter 3 of the Phillips text. And again, this one relies on the foundations from Chapter 3, which has the concept of interrelationships among various sources, the importance of conducting multiple keyword searches, and searching multiple jurisdictions, and reading multiple secondary sources. I apologize for that puppy outburst. It's about 4:20 my time, and it's also a really important time for dogs to start getting hungry and playful and that sort of thing, so I apologize. But I have to say something funny. It's better than what I hear on this one lady I listen to on on her YouTube channel a lot, and I mean it, for 10 years, because I've been listening to her a while and listening to her old stuff too, not 10 years, but a long time. You can hear the battery is dead in her smoke alarm with that little chirp, chirp, chirp. I do not know how anyone can live with that. I couldn't. I would be an absolute crazy woman. But anyway, I love her dearly. She has great stuff. But moving on. Slide advance. Okay. Again, I recommend you go back to Chapter 3 and listen to the lecture, read the chapter again, because it is so important to the understanding of your research decisions in your research for case law, for your case scenarios that you research. It covers the court structure in case law and the 3 branches. It looks to the court system, the different types of case law, mandatory versus persuasive, the authority of the mandatory or persuasive nature of authority, and the multiple sources of law and the legal sources and how they're interrelated. This is an important chapter, Chapter 3, as it's probably, as far as your thought process in legal research, when you're searching, Chapter 3 is a very important skill to obtain. All right, once again, I won't cover these as in-depth as I did in the last one, but if you look at your strategies, you need to use databases or books. Many people still do, but most people are today using databases like Westlaw, LexisNexis, or Lexis Academic, or Lexis in general, FindLaw, and that sort of thing. We need to integrate those in. We can integrate those tools such as Lexis and Westlaw in certain ways as we navigate the process of research. We can compare and contrast the multiple and related legal resources with our strategy skills. And the importance of the date and the source of law is paramount also in determining whether the case law found is valid and correct. When we're constructing research questions in terms of case law, just like research into legislation, there are keyword searches, and we need to use many different searches using different combinations of the legally relevant facts. You always have that option of when you find that one good case, it's a wonderful method, when you can find one applicable case that leads you to applicable sources, other applicable sources. And you need to pay attention to your filters and the databases you select. And as pointed out earlier in the earlier Chapter 4 legislation lecture, you need to pay attention to your filters and the databases you select. Because again, the closer you get to where your answer is going to be, and especially in a jurisdictional standpoint, which is covered so heavily in Chapter 3 and a little bit here, you'll need that to ensure that you are getting valid law that is applicable and preferably mandatory in your state. Choosing the right database is, in my opinion, your first step, and then using the filters in Westlaw and other resources like Westlaw to hone in on what you're looking for specifically in terms of the larger picture of the type of resource, ensuring that you can change them up in many ways. There are many options, and there are advanced options too. Come on, sorry, slides not venturing forward with me here. There you go. You can use the Mr. Boolean advanced searching, and these techniques are very useful. I will repeat a little bit of this from the Chapter 4 legislation in case some people are just watching this one today. And when we use advanced techniques, we broaden or narrow our search. And quotation marks around words, they tell the database you're looking for that word exactly, or two words, whatever that may be. You can put them around each other to help you. /S means the same sentence. /P means the same paragraph. Exclamation means to search all endings of a word. And then you can also do a field or segment searching or exclude certain words or phrases. In my experience with using Boolean, I found it was a little bit more appropriate to use these techniques to narrow my research when I had too much delivered to me on my initial research. And you'll see the problem when you see it. In other words, you'll get your search results and go, oh my goodness, I have too much. What am I going to do? I need to cut this back somehow. And so it's using the keyword, the Boolean search to help your search technique narrow down the research in cases like that. When we construct research questions for our case law, just like with our legislation, we'll use keyword searches. This one is particularly applicable to the one good case strategy. Again, repeating myself, but filters for your jurisdiction is very important, especially in case law research, because you'll get too much if you're not very careful. Go outside of your jurisdiction only when you can't find it where you are. And then the advanced searches and Mr. Boolean. Lists that you look at in case law is the same is similar to what we see in legislation. At the beginning of the book, there's a table of contents. Again, we can well, I won't go any further with that, but sources found in your sources, or sources where you can also find lists, is in your annotated statutes and case digests. We'll go into a little bit on case digests here in a little bit. And then their legal topics, the type of list, and this would be something like key numbers, that they use legal topics, the digests use legal topics to help us find case law. And we'll get a little more in depth on that. Also, right after the beginning, in annotated statutes, in administrative regulations, you're going to find that the source of law, annotated statutes, there's something right at the beginning that's a list, and there's also a table of contents. At the end, there's an index, and it depends on, mostly case, the sources that we find these things are in those case digests, annotated statutes, and administrative regulations. At the beginning of source, you'll see a list of legal topics. After the beginning, there's typically a table of contents. At the front of the book, it's the legal source. I use again the analogy of our textbook. At the beginning, there's a list of topics called a table of contents. Within the book, after the beginning, there can also be further description of the contents. Sometimes an extended or more robust table of contents with subtopics. And then at the end, an index in the back of the book. And they are often alphabetized by subject. These can be very, very useful. Now for the miracle of the digest. The digest system of West is amazing. And I will point you to pages 129 through 132, a little portion of 132 of the book. This lecture stems from A Practical Guide to Legal Research and Analysis for Paralegal and Legal Studies Students by Margaret Phillips, a 2020 publication by West Academic Publishing. So both Westlaw and Lexis Lexis uses this too. They use I don't use Lexis, so I can't really teach from it. But both of them have a subject matter index. It's beautiful to get to the subject matter index. It's the index to the index, and that's a way of looking at digests. Digests are an index of all the cases that are published by West and by the courts, of course. Of course, it chooses to publish it. It goes to West editors. West then publishes it after editors review it and do some work that we're going to talk about in a minute. But this, the subject matter index will be basically it's the index to this digest system. And the digest system itself is an index. So my way of thinking of it is there's an index to the index. West uses headnotes, and I have a warning label on that in the next slide. Headnotes are the backbone of their index system and their blurbs, and we'll look at that on the next slide. What they have is a list of digest topics, and this list of digest topics will give me a drilled down outline of the topic that you want to research, and it's organized quite brilliantly so that new topics, as new laws emerge, new problems emerge, they do expand on the digest. Digest topics also they have topic numbers. So they're numbered, and lesser topics have key numbers. And this type of indexing will give you everything you need under that topic and key number. This way you can see more than what you found. I mean, even the one good case theory can help you, a digest can help you with that even further by looking into the digest under the topic and key numbers that are used in all the West case law publications. You find them in the headnotes, and so the cases themselves will include headnotes. I'll talk about that on the next slide. But those digest topic numbers and key numbers are also in the headnotes, which gives you a directional to other cases about that topic and key number. It's a brilliant system. So here's the short summary first in the black text here. The headnotes are short summaries of the legal rules relied on in each case. They are the backbone of the West Digest system, the headnotes are. They are blurbs. They're a digestion of each holding and/or, not always the legal rule is included, but and/or the legal rule relied on in the case. It gives a researcher the gist of the case. It's like, okay, this sounds like I'm going down the right rabbit hole. And they're short, like I said, blurbs. And they're written by editors at West. They are not part of the opinion of the court. That's the warning label. You're not going to cite or write about the headnotes. So you'll never rely on the quoted material in headnotes, and you'll never rely on the headnotes anyway, as the last point makes. You still have to read the case. You have to pick out the legally relevant facts from that case and discern them and discern the holding on your own. But case holdings, and one up above that, the bullet point above that, these are the legal rules relied on in a case. It's not always legally relevant facts of the case. And I want to tell a story. There was this Robert Baring was his name, and I don't know how old he is now, but he used to be the head law librarian at University of California, Berkeley or something. He was the head law librarian. He told this story in a video I used to show to students. He said, never rely on the headnotes. They're a way into the research to look at the case, see if you're interested. He said, but what they say, you never know if the headnotes are really spot on. You never know when the editor that gets that case and writes the headnotes has broken up with someone the night before. I don't know, maybe had too much to drink the night before. Whatever has happened, having a bad day and not really thinking clearly. By the way, we're still all human. And you don't want to rely on those just because of the simple human infallibility that we possess, each and every one of us. So be careful about headnotes, but by golly, they are great for your research journey. We'll learn about those. Back to chapter 1, primary sources are always more important than secondary sources, so we're going to look for the weight of our research sources using this strategy of what's the primary source. And when we do have a primary source, we're going to look to its date, and we're going to look to whether it's mandatory versus persuasive precedent. And so the precedent is something that applies in case law, so I wanted to make sure that you understand that. It applies to case law about legislation, so don't forget that. But it is important to understand this mandatory versus persuasive precedent again, and Chapter 3 was our beginning point on that, and I'm revisiting it a little bit in a different way today. The relevancy of the case in light of the legally relevant facts. Backspace to the previous slide about the beauty of the digest. We still need to determine the holding, discern the holding and the facts, the legally relevant facts from a case report. So that's super important. Those things will help us place them in their weighted category. So how do we rank a case? We have mandatory and persuasive precedents in state courts, where I'll start. This pyramid illustrates the court system, and we're going to start now at the top of the court system, the court of last resort, and again, we are in state courts when we have this on this slide. In the state, the court of last resort will have mandatory precedent for all mid-level courts of appeal in that state, and all trial courts and other lower courts in that state. So when the court of last resort makes a decision, it's mandatory precedent that covers a lot. It covers both the mid-level and the trial court. So these two are going to be covered by the precedent of this court when those decisions come down. Persuasive precedent from courts of last resort from another state other than your own, then would be persuasive precedent. In the state court, when we get to the mid-level appellate court, we have the mid-level court of appeals here. All trial courts in the same jurisdiction are required to follow the same mandatory precedent. But it's persuasive for other mid-level courts in that state, but in different jurisdictions. And trial courts in that state are also persuasive to trial courts in that state, but if they're in different jurisdictions, excuse me. Let me see if I can put this into some better perspective than just this slide does. In a previous presentation on Chapter 3, for example, I believe I included the case of Pardo versus State. It's a criminal case where the court discusses mandatory versus persuasive precedent in relation to different jurisdictions. And for example, in Florida, our mid-level courts, there are 6 district courts of appeal. That's our mid-level court of appeals, and they are organized geographically. If I'm in a mid-level court, either in the trial court of that mid-level court or in the mid-level court itself, if I'm in that jurisdiction, I have mandatory precedent. But as soon as I step outside of that jurisdiction, let's say from the 6th District Court of Appeals and I'm in the 2nd District Court of Appeals, 2nd District Court of Appeals and the trial courts below the 2nd District Court of Appeals do not have to follow that precedent because it's persuasive and not mandatory. But as we're going to see, I think on the next slide, I don't know why this, when we're in state courts, again, now we're at the trial court. Trial court makes decision, and there's nothing mandatory about their decisions. Now there are trial court handbooks and bench books where trial courts are following some precedent that's more informally established, but they're published in their own books and they're not published to the world, and they can be beneficial in persuading the court that they should decide one way or another. But again, in trial courts, there's no mandatory precedent to those. The chief judge of that trial court might have some mandatory ideas, but not really. They're also persuasive only. The trial court decisions are persuasive precedent for other trial courts as well. But there's nothing mandatory about a trial court decision other than a custom or a tradition. Federal courts, same thing, mandatory and persuasive precedents. The court of last resort would be a mandatory precedent in the federal system for all federal circuits. So if something is coming from the court of last resort, the United States Supreme Court, all federal circuits have to follow it and all federal district courts have to follow it. This is the supreme law of the land, which means it applies everywhere and that's back to Marbury versus Madison from Chapter 3. All state courts, it's also mandatory precedent for all state courts if we're for decisions about federal law. So keep in mind, federal versus state. State courts do hear federal claims as they move up the pyramid to the court of last resort, and then if it's a federal question, it can go to the United States Supreme Court. But all state courts are bound to the mandatory precedent of the court of last resort, the supreme law of the land. And we're in federal system, so that's the United States Supreme Court. And then it's persuasive for itself, but the Supremes are able to change their minds. We've seen that a lot. All right, so in the mid-level of the federal courts, the mid-level appellate courts, we have courts of appeals in the United States legal system, and the circuit courts are what they're called. District courts are the trial courts in the federal system, and they all have circuits. So the circuit is a geographical boundaries of the district court system in that circuit, and so district courts in their own circuit have to or have mandatory precedent and they follow the decisions of the courts of appeals that are precedential decisions. Persuasive precedent, though, as soon as I go outside the boundaries of that circuit, it's persuasive. As soon as I get to the district or trial courts of different circuits, I'm still in a persuasive nature. So district courts, by the way, I didn't mention this here, these are trial courts, we'll cover that again, but the district courts in their own circuit are their mandatory decisions. And then the other circuit courts in the different circuits here, in the trial courts, persuasive outside of our circuit. When we get to the trial court, we have the district courts. Those are trial courts in the federal system. There's no mandatory precedent that comes from district courts in the federal system, but it's persuasive for other district courts in their own circuit. It's a lot like the state thing I told you about. It's the trial courts don't have precedent, but they might have some persuasion to follow those rules at others for consistency in decision making. in district courts and other circuits. Outside of the circuit that you're in, that the case comes from, it's also a persuasive precedent. And when you're applying state law, the state courts. So when the district courts apply state law, state courts have a persuasive precedent. Decisions from the district courts of the federals, when they are applying state law, think of diversity of citizenship jurisdiction. That's where the federal courts hear cases that are based on state law. And when applying that, and decisions are made by these trial courts, when they apply state law from those decisions, the state courts follow it as a persuasive precedent. So I highly recommend that you review Chapter 3 more than once in this class, especially when we are researching case law. It's very essential that you understand the court structure, case law, in our 3 branches, and hopefully those past 6 slides have helped you with that. There's one more step, and that's checking what is the weight, the relevance weight. How is it relevant? So you're reading a case, and it talks of rules and facts. When this is not like precedent, okay? This is the relevancy. We're not talking about precedent at all here, even though it will mix into your brain when you find cases and you're trying to determine its applicability and whether it's mandatory or persuasive. That's a huge important question. But looking at a case, reading a case, deciding whether it's relevant to your legal scenario, that the solution you're trying to resolve in your research, it's of low relevance when the case applies a different rule and different facts. Sometimes we see that we're close, but we're not quite there because we haven't gotten to the medium or high relevance. So let's go to those columns next. Medium relevance is where the case talks about the same rule, maybe a different element of the rule, in different facts. Or the same rule, same element, different facts. Or same rule, different element, similar facts. We're looking for these 3 things, rule, element, facts, to determine the weight of the relevance of a case. And we can have medium relevance because we're not as low on the relevance scale as different rule and different facts, but we come up higher and we look at those three criterion in relation to the relevance of it. And then here, when we have high relevance, we have all 3 things. Everything's the same and the facts are similar. Another way of explaining that too, we call on all fours. And when we add in the 4th, you guys, please, I'm almost finished. When we add in the 4th, on all fours, same rule, same element, similar facts, and it's mandatory. That would be the 4th. It's not listed here because we're talking about relevance, not mandatory. But 4 on all fours, that's when you have a really good case you've found. Westlaw and Lexis are also, as the slide title says, arguably the most important research task. Checking for red flags and yellow flags in Westlaw, or in Lexis you would find stop signs and caution signs that tell you to read on, look at what we call the history of the case, and that is like a blowback of what happened since the case. Other cases come along, it cites the precedent, maybe the court has made a different decision, and so you have to make that judgment based on key cite, which is what we use in Westlaw. So that concludes our case law. Again, 3 and 4 are very important together. I prefer students at least try to look at legislation separate from case law because of the helpful, there are overlaps, but there are differences too. So thank you very much for listening today. This is a citation in APA format for the Phillips textbook that this this lecture relies on. and that's legal research and analysis for paralegal and legal studies students. Thank you very much.